David, one thing I forgot to mention that Claire and I were talking about was the chair had asked to get the AI clinic bill put in, but it was never put into the subcommittee. So I don't know what we can do about that. But we're live.
Good afternoon, everybody. It's March 28th. I can't believe it, but it's March 28th, and this is a meeting of the House Criminal Law Subcommittee. We have on the docket a few bills related to deep fake and revenge porn, essentially either real or simulated material that is being distributed without consent. We had a number of bills from Delegate Lopez, Delegate Pippy, Delegate Warman, and Senator Hester has sent one over. And so we will be taking a look at these, both in the hopes to send work back on the Senate bill primarily, and then we'll see what we can do on the House bills. So our committee counsel, Claire, has put together a nice head-to-head comparison of the bills. It's up on the screen. And just my, very quick rundown. Someone needs to go on mute. Yeah, my very quick rundown of these four bills. The Senate has sent over on the Hester bill a combination of civil and criminal penalties, with, I believe, the civil just applying to the fake representations. And the Lopez bill is a civil-only bill, and it does encompass a civil remedy for both the deepfake and the revenge porn issues. The Warman bill was about the platforms that host content and having them have a removal policy for this. So that's a newer issue for the subcommittee. So we'll have to see if we've got the capacity to take on that whole topic. I did flag one on the note, on Warman's note. I did flag one, I believe, one change in the Senate bill between last year and this year. I think last year's bill had a carve out so that the prescribed behavior was not, the penalties would not apply, I think, to the web hosts in last year's Senate bill. And I don't recall seeing that in this year's. And obviously, if I have any of this explanation wrong, I'm sure the folks on this call will let me know. And of course, we've got the Pippy bill, which I believe is a criminal-only bill this year. So that's the very quick rundown. There's a few places of consensus, and I'll just throw those out there for now before we get into some of the intellectual conundrums in what we're doing here. The consensus appears to be, across bills, a desire to do a civil remedy. I think for the fake pornography, the defamation angle seems interesting because it is in fact defaming folks in some way. And for revenge porn, a more general civil remedy. So that seems to be common between the House and Senate bills. And across the bills on the criminal penalty, there appears to be agreement on basically making these all comparable to the existing 2-year misdemeanor penalty that we have on revenge porn. Now, where they start to differ is in definitions, and how they are chopping these offenses up. Um, and here, I just want to flag a few things. The chair had raised questions about whether if you're say if we make the law apply to the fake pornography as opposed to the real pornography, are we somehow making people needing to prove that it's not their body parts in some way? Um, so that's one issue implicated in the definitions. The other one that I would flag, and we can open it um, perhaps to the sponsors or proponents of the bills before we open it for committee discussion, because I'd be curious to hear how the stakeholders would respond to some of these questions. My questions at the onset are about some of the intent requirements that are lined up here, both the intent requirement in existing law with respect to revenge porn and the intent requirement that's proposed for um, the deepfake pornography in the new language this year. And so, just to give you a flavor of this conversation, the revenge porn existing 2-year criminal penalty has a requirement that that you have a reasonable expectation that the image would remain private. Uh, and I just want to flag that for discussion, whether we need that. And then in the new language, we are saying it's not just that you are releasing, you perhaps made a fake porno of someone and you're releasing it to the world without their consent, but there's an intent requirement here in both the bills that you're doing this with the intent to harm, harass, intimidate, threaten, or coerce. And I'll ask again, for the benefit of discussion, do we need that intent requirement? Is it not sufficient that someone made a fake pornography without the consent of someone and put it out there in the world? And the reason I ask this is from the onset, I'd say you're going to have some people who are producing this pornography for their self-pleasure. I'm not sure any of those intent prongs are necessarily met um, with that, and it made me wonder if we need the intent at all. So let me drop it there. And so what and before we get to the member discussion, I do want to offer it. Is Senator Hester here?
Hi, this is Bridget from Senator Hester's office. She's actually voting right now, so I'm here on behalf of her, but I've been working closely with her and some of the advocates on the bill, so I can answer any questions.
Okay. And sorry, who are the advocates that are proponents that we have here today, Chris?
Debbie Feinstein, Lisa Jordan should be here. And then we also have representatives in the unfavorables from OPD. And I believe also in the favorables, Lori Ruth, I believe is here.
We
Joyce
also
King.
worked with Joyce King, yeah.
Okay. So I guess before we kick it over to members, again, between the different versions, it looks like, people want to do a 2-year, try and make this similar to the 2-year misdemeanor revenge porn penalty. And then there's been some movement to create a civil remedy. I guess so there's 2 questions I want to flag from the jump. And one set is from Chair Clippinger and the other is from me. And I guess they kind of pull the bills in different directions, these questions. But his question is as to whether if we have a separate definition for a deepfake and a separate definition for revenge porn, one is real and one is fake, are you somehow making someone prove something as to, how do you prove that image is not you? I guess that was the question the chair had. And my question is uh, related to that. It's as to these intent requirements that we're putting into both, and they're different, and I flagged this as an issue last year because the intent requirements, I think, for one of them would have stood in the way for the other, between revenge and deepfake. But I'm smelling this intent question again. So why we have these intent requirements in both the original revenge porn law and in the new proposed one, and why it's not sufficient that these were distributed without consent. What's the legal application that I'm missing here that requires this intent language? So those are the questions. And I guess so if anyone from Hester's office, or the proponents of that bill, have any discussion on that, it would be appreciated.
I think that I'd be happy to kick it over to Lisa Jordan to start answering the question.
Sure.
Thank you, Mr. Subcommittee Chair, members of the committee. Lisa Jordan with the Maryland Coalition Against Sexual Assault. I agree with you, Mr. Subcommittee Chair, and Ms. King and Ms. Feinstein and I met this morning and provided your staff with an idea to try to create a unified definition of visual representation that includes your actual image, a computer image, and everything in between. Like that, there really should be no distinction. We also talked a little bit about the reasonable expectation of privacy, and my recollection stems from when revenge porn was originally enacted. And I think at that point, it was a delegate from District 17 who was very concerned about that. And so that is in there. I believe some of the concerns stemmed from a First Amendment issue. I also will say that I think that most
I'm sorry, can you articulate the First Amendment issue?
I'm sorry, I don't remember all of the details of the First Amendment issue, but I don't know that I share a great concern about the reasonable expectation of privacy, and that I think that we all believe that images of our intimate areas should be private, whether they are computer generated or actual. And I don't think that you need to see an image to have an expectation of privacy. Consider, for example, images taken of you while you're getting undressed and you don't even know they're being taken. You would still feel like those images should be private. They would still fall under revenge porn. I'm not sure that is as much of an issue. Certainly the idea that you seem to be expressing, Mr. Subcommittee Chair, that we shouldn't have to prove harm, that just posting an image without someone's consent should be criminal, does seem to me to be enough, particularly because if you retain the indistinguishable from another actual and identifiable person that is not drawings, cartoons, sculptures, or paintings, that seems to protect the artistic issues, the idea of, oh, I wasn't posting something to harass someone, I was posting something to express myself. That was part of the First Amendment issue. And you probably could beef that up a bit more if you wanted to. I mean, that was my...
I worry about keeping some of this wonky language in here and making what ought to be a straightforward inquiry a little too complicated. I have to be perfectly honest. And so, I just keep thinking of scenarios that don't seem to meet these intent requirements we're passing up. And so I'll just float a few scenarios that I think whatever we're doing in the law ought to cover. One is you have two intimate partners and they share photos with one another, and then they break up, and later those are released without consent to the world. That scenario ought to be covered. You ought to be able to cover a scenario where photos were stolen, perhaps, and released to the world. And then the third scenario where the photos are manufactured perhaps for someone's own pleasure and released to the world.
Mhm.
And I guess it's not clear to me. And again, you know, we can just do some nips and tucks here, hopefully to fix this. But I guess it's not clear to me that all of the different versions of the bills are necessarily covering these scenarios. And in some instances, it's these weird additional things like the intent requirements where it just seems to not meet that scenario.
So, Delegate, all of those scenarios were discussed originally with revenge porn and the analog images, and I think that they would all fall under serious emotional distress or economic damages. But you're accurate that those are the things that would be argued. You know, the countervailing issue was we don't want to stop art, we don't want to stop personal expression, we do want to be able to use the human body, you know, as a form on the internet. But none of those hypotheticals you offered really intrude onto art, and I do think that they would fall under serious emotional distress. Even the image used for personal pleasure, I mean, I think that causes people distress, and I suppose you could take out the word serious.
And sorry, I'm actually looking right now. I'm looking at page 5, line 10.
Of which one, sir?
Senate Bill 360. So this is the kind of prohibition I guess we're contemplating.
Sorry, I'm having some computer issues there.
While Lisa's pulling that up, could I jump in on that specific inquiry?
Yes.
Just, you know, and I think Lisa and Debbie would agree. I mean, the intent to harm, even if it's for and we've argued this in court, that even if it's for personal pleasure, there's a knowing, you know, that is harmful, that the image is being utilized, even if it's for your self pleasure. There is a harm to the victim regardless. So while I understand the concern, I don't believe that I don't think
You don't
the issues
think that's going to hurt you in court?
No.
With a case
I mean,
like that.
at least we have not had that issue. I think, and I think Lisa had sent out our draft of what we think addresses the chair's others concerns with. I think that, you know, if we redefine just visual representation to include AI computer generated, that solves a lot of the other miscellaneous concerns, and it's a clean way to move forward.
And Delegate Moon, it would take out that whole item 2, which includes the knowingly distribute with the intent to harm as a separate paragraph applying just to computer issues. And so then that leaves you with the current law may not knowingly distribute visual representation, but define the visual representation. Again, leaving the law as it is with the intent to harm, harass, intimidate, threaten, coerce the person under circumstances the person knew, did not consent, or reckless disregard, which I think has been, and certainly Ms. Feinstein and Ms. King will correct me if I'm wrong, but I think that this has been effective in court. Our concern, like the chair's concern, is that we not create something separate for computer generated. We just keep all images on a continuum in the same place.
All right. Chris, can you put on the screen what they are proposing? And so this is not what came out of the Senate. This is the advocates are proposing an alteration to what came out of the Senate to respond to the chair's concern that if we have a separate revenge porn and a separate deep fake section, you run into these issues of proving whether it was real or fake or not, when you can just have a definition that encompasses them both.
Mr. Subcommittee Chair, I just want to point out that in Delegate Lopez's bill, if you want a clean version of that, that's what we did. And all we did was alter visual representation to include computer generated images. So based on the discussion, it seems like that's exactly what's in our bill. So if you want a cleaner version of that, you can pull up HB 663 to see what that would look like. And all it is an alteration of the definition of visual representation to include computer generated images and not any of the additional text.
Got it. Okay. So the Lopez bill was going in that direction.
Mr. Chair, I had my hand up. I don't know if you can see that or.
Go ahead.
All right. Just on the reasonable expectation of privacy portion, I think you raised an issue that does not appear to be addressed as of yet, and that is, unlike an actual reasonable privacy where people are actually together with like a computer generated image, there may have never been a private thing. I mean, it could be wholly generated, where I take your facial whatever from a photo that I got offline, and then I attach that to, I guess, what could be your naked body, and then share that around. And so I'm assuming we've not addressed that, but yeah, that is a concern that you wouldn't.
You know what? I'm sorry. You're correct. I forgot about this particular phrasing of the concern, but this was one of the issues with when you merge the definitions. This was one of the questions I had flagged from last year, that if the images are wholly fabricated from public, like a public, my headshot from my Facebook page, and attached it to some actual pornography, and then you put that out in the world, well, there's actually not a reasonable expectation of privacy in my public headshot. And so that did raise a question as to that particular type of pornography, whether it would escape that. So I guess the question then is, in what's being proposed here, this sort of one definition of visual representation to capture both scenarios, would we maintain that? Would we need to keep that other language or not? The reasonable expectation of privacy, I guess, is.
Yeah. So, Mr. Chair, I was just going to say, and I'm not trying to advocate for my bill or anyone else's bill for that matter, but in our bill, we did contemplate that scenario. And I would imagine with like the Taylor Swifts of the world, most of these AI type scenarios will be just that, where somebody takes a photo from online and then they attach that to some sort of compromising thing and then distribute that. And so I think in our bill, we addressed that by either removing it, or we added the computer generated images in another section so that the reasonable expectation of privacy was not a requirement. And so I know you brought that up early in the conversation today. I just wanted to touch on it, and then you guys can go back to the other stuff. But I think that is a thing for sure.
All right, let's hear our counsel. Claire has her hand up. Maybe she's got something insightful here.
I just wanted to mention that on this issue, House Bill 1248 does seem to address that with a clarification to current law on page 6 of the bill, lines 5 through 8. It qualifies that clause by saying, if the visual representation was created or generated with permission from the other person under circumstances in which the person knew or reasonably should have known that the other person had a reasonable expectation that the image would remain private. So I just wanted to point that out.
This is adding to the revenge porn definition. I see. Okay. And sorry, can we, the version of language that, Lisa Jordan sent around, is that in a reprint format or is it just as to that one section? Sorry, can you flip back to it for a second? It is just to that one section.
Mr. Chair, it was loosely based on the Senate bill, but we were unsure which legislative vehicle you would want to go with. So we stuck with that since it seemed to be the most commonly used language.
Got it. Okay. Why don't let's do this. We'll quickly flip to OPD for a minute of response to this conversation, and then we will go to member discussion.
Thank you, Delegate Moon. Just for everyone, my name is Jeremy Zach. I'm from the Public Defender's Office. I just wanted to go back to the issue of intent that was raised and how important it is that we do keep this intent to harm, harass, etc. in the bill. Otherwise, to remove, we're just focused on the criminal side of this. To remove criminal intent would create a strict liability offense where anyone who would distribute or redistribute this deep fake could run afoul of this law. The whole purpose of a deep fake is to trick others to think this is a true image. And those images can get redistributed, probably along the internet or through text by people who receive it, thinking that it's not something that doesn't have consent. And when you're 3 steps down the line, the person all the way down that chain, they would have no idea that the original person depicted or the original distributor was trying to harm someone. So we would be bringing people in who had no intent to harm and had no intent to embarrass or defame. So we have to think about not just the original wrongdoer who's creating and distributing it, but then all the other people who might fall into this category. So that's what we want to address about the intent element.
All right. Delegate Kaufman has had his hand up for some time, and then we'll have Delegate Cardin.
Yes, thank you, Mr. Chair. Can you hear me?
Yes.
I want to just, many of you, like you, Mr. Chair, Delegate Cardin, are lawyers, and I'm not, but I wanted, and Delegate Bartlett too, but I just wanted to maybe make a suggestion because I thought it worked really well. Is there a way, because with the porch piracy, our friend Delegate Conaway got top billing, but we incorporated parts of Delegate Tolz's bill and Delegate Solomon's bill. And so after listening, I think, of course, it's your subcommittee, Mr. Chair, but I think that's probably the best way to go. Could we take bright ideas from everybody's bill and make it one sort of omnibus bill? That's what I think would be great.
Certainly, we can move in that direction and try and move sponsors and whatnot. Delegate Cardin.
Thank you, Ms. Chair. Thank you all. It's great conversation. I just wanted to add that I thought, because I actually sponsored the original revenge porn legislation back in 2012, and we were required, like part of it, and this was with Professor Citron, who's now at UVA, but the intent was important in order for us to get it passed. And I think that I would assume, maybe I'm wrong, that part of the reason for it is that it was mimicking the original revenge porn legislation. That being said, if the state's attorney doesn't have a problem with proving intent, I don't know why we need to have that discussion. Let's just go with it. That would be my comment.
Yeah, well, I guess it was, and again, this is part of the reason I think it's a little more interesting this year is that up until today, we were keeping the revenge porn and the deep fake we were basically having two separate definitions and two separate sections of code, so that an intent requirement on one wouldn't impact the other. But now, if you putting them all in one, we just got to make sure that the intent requirements for revenge porn are going to be the same, are going to be able to be met for people who are coming in the door with deepfake cases. And that's why I think Delegate Pippy's point is an interesting one. If you're coming in with purely manufactured out of public material, can you meet some reasonable expectation of privacy prong that we put in your law, years ago for something quite different, stolen images or whatever that, your spouse photos are going to be in a different expectation of privacy than your Facebook profile. So I guess it could just be that we don't need to deal with every scenario, but I just throw that out there as one of the questions that's raised when we combine the two into one definition. Do we then combine the intents too and the prongs? And and this is again why the language that that was provided to us today to create this combined definition is not in a reprint format. So I imagine that means we're just changing the definitions, but keeping the revenge porn prongs as is, but making them apply to deepfakes.
Can I ask the state's attorneys, maybe when is publication not an intent to harass or harm somebody? I mean, if it's
Right.
Well, it's the other way. I guess we're
Part of
bringing
the
in
concerns with the intent.
it's the
Go
other
ahead,
other
Mr. Chair.
requirement that's the question. If we bring them all under one definition, does the Pippi scenario get excluded from what we're doing here because it can't meet the reasonable expectation of privacy prong?
I don't think so, but I'll defer to Debbie, but I don't think so. I mean, Debbie and I might disagree on this. I think that there is a reasonable expectation of privacy on an image of me, regardless if it's an AI generated body part of me. That I think what's important about revenge pornography, it's indistinguishable. So it's almost like I have ownership now because this is representing of me, and therefore I do have an expectation of privacy of it. So that makes sense. But Debbie, if you disagree.
I don't disagree. I agree. And I think the concern that Delegate Pippi raised, if you are putting images of yourself out there, you're not, a Facebook profile, for example, or a Facebook picture. The problem is then when it's combined with some other body parts that are AI generated. So there is a reasonable expectation of privacy that your face is not going to be combined with something else. And I think that those are the types of cases that we've seen, and those are the ones that have been problematic under the current law.
Have you seen case law on reasonable expectation of privacy about combined
No,
imagery or something like that?
because to date we haven't been able to.
I'd be curious to see it if you did.
Right. To date, we haven't been able to prosecute those kinds of cases because it has to be an identifiable, the whole body, everything has to be an identifiable person. It can't.
All right,
be,
let's hear from.
Can't be generated, if you will.
Got it. All right, Delegate Embry, and then we'll go circle back to OPD.
Thank you. I think the focus is on the language about consent rather than reasonable expectation of privacy. You're not consenting to the distribution of that final image. So it's the sources of what goes into it. I just don't think is what's important. It's the final image. It's consenting to the distribution of that. I think to me, that's the focus. I'm sort of restating what's been said, but I just think the reasonable expectation of privacy, I think, is actually not core to this crime.
Not harmful.
It's the intent, which I think the prosecutors have explained they're comfortable with, and then it's the consent piece. which no one is consenting, right? Even if you consent to having your face on a public website, you're not consenting to the product that involves your face being distributed.
All right, let's flip it back to OPD.
So the term reasonable expectation of privacy usually applies to property, either property you own or things like your house where people can't peep through your windows. So it is difficult to apply reasonable expectation of privacy to a completely invented image. And I understand the point people are making that you have privacy in your body, but if it's not an actual image, I'm not sure how the court is going to interpret this term reasonable expectation of privacy. As a defense attorney, I can tell you I would argue in court that if it's a completely computer generated image, there is no reasonable expectation of privacy. Going back to what someone else said, when is distribution not an intent to harm? Again, the redistribution. If these images are designed to fool other people, those other people may distribute it without intending any harm, without even realizing there's another person who would be harmed if they just show it to a friend or send it off one more time.
With all due respect, that's ridiculous. That if you are,
I'm sorry, I've had cases like this. It's not ridiculous. If I receive an image that I've never seen this person before, and I don't know who they are, but it's done in such a way that maybe I think it's from an OnlyFans page or something like that, and I just show it to someone else saying, hey, isn't this cool? I don't know that I'm harming someone. I think the original creator of the image, yes, you can absolutely say, because they're the one creating it without consent, they're harming someone. But down the line, you're going to have people who have no idea where this image originated, that have no idea it's actually a real person. And so removing the intent to harm puts all these people in harm's way. And the way these things are so easily distributed, you could have thousands of people coming in under this bill. So I would just stress that the intent here is critical to making this work.
And sorry, just for my reminder now, is the penalty on the distribution or the production? Or both? Can we actually
It says knowingly distribute. Senate Bill 360, page 5, line 3.
Yeah, okay. Yep, there you go.
I will say, this is Elizabeth Hilliard from the Office of the Public Defender. We do have examples of this, but we would have to de-identify all the information to be able to share it. I'm not sure, but we have definitely seen this charged. The like secondary, tertiary, reposting, redistributing charged.
On a revenge
Yes.
porn case?
Yes.
May I ask a question about that?
Yeah, go ahead.
Oh, thank you, Chairman. In that case, how would we prove? I guess that my concern is we would still have to prove harm. So, someone that's sort of a downstream person, which is what's being described, they would have to have the intent to harm, harass, intimidate, threaten, etc. So we wouldn't be able to prove their harm, I don't think, under those circumstances. And I've personally never seen a case like what's being described, but I certainly appreciate that you might have.
Right. We're saying that's why the intent to harm requirement is necessary. Because if you take that out, then you would be able to prosecute anyone down the line.
Okay, I will concede this then, just for, to keep this discussion going. If folks are agreeing to keep the intent language in there, let's just keep rolling on it. I have to ask now though, did you intend to exclude production in this crime? It seems like production is the greater offense versus distribution.
I will say, Mr. Chair, if I may, in some conversations that we had in the initial drafting of the bill, we were talking with those that might prosecute it and saying that there's not really much you can do if someone's creating this picture in their basement for themselves. You can't like go through their computer and find the picture. So we felt that distribution was the greater threat here, but others can chime in too.
Yes, Claire.
Current law only prohibits distribution of revenge porn. And that's like if you're looking at Senate Bill 360, page 4, line 22.
Well, I guess that would make sense though, because in that sense, it only becomes criminal once it's redistributed. The production was presumably legal because it was consented to, at least at the time. But if the production itself was without consent, then it would seemingly be a different offense. Go ahead, Delegate Embry.
I was just gonna say, I take your point that it's distasteful, but I just think it's the making it public or sharing it with others that I think is the harm to victims.
Well, I'll tell you, one of the reasons I'm asking is whether we intend to include the chain of redistributors. You know, if something goes viral, for example, if a celebrity image goes viral, you know, it's certainly, you know, moral culpability for criminal mens rea for the person who produced it and the initial publisher, sure, certainly. But the way the law is written, I'll concede we're writing it in a way that will take, you know, all the retweets into it also, for what it's worth.
But that's true. Sorry, that is true currently of revenge porn, right? It would include the redistribution.
That's full.
I guess I guess
Yes.
OPD is telling us that's the case. Yes.
If it's with intent to harm and without
Right.
With
consent.
intent to harm.
Correct.
Okay.
Right. So that's why leaving that portion is important for that downstream.
Okay. Since everyone's accepting this intent to harm, I'm not going to question it, but I really wonder if it's, you know, celebrity's name. Hey, everyone who's a fan of this, come check out free pornography. You know, it's intent to harm is questionable, but if you guys are saying it's a it's a go, I'll accept the logic. All right. Well, let's skip quickly over to the civil aspect of this for a second. Why don't we start with the Senate bill again? I believe there was a civil component on this one. Am I correct? It was on the Senate bill too, the civil bit.
Yes.
Yes.
Chris, can we scroll to
Yeah, this
might be
page number.
at the beginning. Yeah, here we go.
Page 3.
And I believe here the civil case contemplated is only for the fake pornography. So, and again, in the defamation context, that makes sense to me. But this is another one of these questions. If we merge the definitions, can we still have this clause here? Is it written in a way that we can still have a separate civil defamation case for the fake pornography? Lisa Jordan's.
Thank you, Mr. Chair. You know, I think that the way that the bill has come out of JPR, and it was also introduced by Delegate Lopez, is just about defamation per se, which, bringing you all back to law school, for those of you who have gone to law school, that means that you don't have to prove that it's harmful. It's just considered, this is going to be harmful. You don't have to prove it. That's defamation. The use of an actual image is arguably already part of defamation law under the false light action. And although I certainly could argue this either way and would not be surprised if MCASA suggests tweaks in the future. I do think that the way it came out of JPR is probably as far as JPR will go. And from our point of view, it's progress for survivors. So our position is that this is a good first step, and I would take the Senate's language in Senate Bill 360 as it is.
Just on the civil portion, or
Just on the civil portion, the language that Ms. King and Ms. Feinstein and I developed for the criminal part, we hope really addresses those issues that were raised by the chair. So for the criminal portion, our goal is to have a unified definition of visual representation. That was just thoroughly discussed. But for the civil portion, creating the defamation per se for fake images or images that are partially fake it's a great first step. So given where we are in the legislative session and JPR's discussions of these issues, our position again is that for the civil portion, the language that is in Senate Bill 360 and also in Delegate Lopez's bill is the way to go for the civil part.
Okay. And again, if we add this civil part piece here to the new combined definition, these two pieces don't mess each other up, right? The combined definition is written in such a way that this part here still works.
So the combined definition would apply only to the criminal law article, and the defamation pieces in courts and judicial procedure. And that
now, would it have its own definition then?
It's already got definitions embedded in it, yes.
Okay, and Claire, do you have some?
Yeah, I was just going to say that would be they would keep the term computer generated visual representation, which would be different than what's being proposed by for the criminal statute.
Okay. Delegate Lopez's office, yes.
Yes, hi. So we have, if you scroll up on the document that you're on right now, you'll see the definitions that are added to the courts and judicial proceedings section. We have exactly the same language, but the only difference is we include injunctive relief as well as attorney's fees and punitive damages. So that's the only thing different in terms of the civil remedies between our bill and Senator Tester's bill. We were actually cross-filed with this bill last year. And so the only difference is that it includes injunctive relief from all parties involved in the violation of this section after attorney's fees.
Got it. And it sounds like...
Oh, I'm sorry. I was going to say, just for information, JPR did consider that because there's a rule that allows injunctive relief in any civil case. They felt like it was adequate. I would love to see that added, but just as a point of information.
Got it. Okay, so I'm hearing a strong signal that JPR doesn't want to move any further on civil remedies on this topic. So why don't we just take that there, and at least for the purposes of a straw poll, I'm going to say it'll be my recommendation and the subcommittees that we take what JPR has done on the civil remedy here, which is basically creating a defamation per se remedy only for the fake images. And if anyone has any committee member has an objection to us making that the subcommittee position as to the civil remedy, this is your time to object. Okay. So let's flip back to the criminal question. Does anyone have a problem with the concept of combining the deepfake and revenge porn, so the published spouse photos and the fake photos and putting them into one definition. And Chris, if you could put that back up on the screen.
Apologies, I might not be following. Which document would you like?
Sorry, the one that was emailed earlier today. Yeah, something like this. Claire.
I just want to mention, I would have to tweak this a bit.
Okay. And actually, Claire, let me ask you this then. Do you feel one of the other definitions of combined language in the other bills is closer to it than this one?
I don't think there really is something like this in any of the other bills. But I mean, technically and legally, it looks fine to me, except I would have to, like I said, I'd have to tweak it just to basically say visual representation includes an unaltered image of a person, a visual representation created without using other existing visual representations of a person, and a visual representation creating using other existing visual representations of a person, period. And then this indistinguishable on the very bottom of that page, indistinguishable from another actual and identifiable person, that is in the other definition. So that would not be a part of the definition of visual representation.
Sorry. Yes, Delegate Lopez.
I was just wondering if I could get Claire's opinion on the definition that's in our bill, which is HB 663 on page 3, lines 21 to 24.
Well, that bill is not modifying the criminal prohibition at all.
It's adding computer generated image to visual representation into the criminal code definition that's currently there.
But it's only for purposes of saying that you can have a civil cause of action.
No, this is part of the criminal code. The civil
Right, it's in
code is
3809, but this bill is not modifying the crime at all.
no, it's modifying the definition included in the crime that's already on the books.
Yeah, I mean, I don't know, I would have to examine that and think about that. If you're suggesting that by adding this definition, it's including the deep fake situation in our current revenge porn crime, I would have to, I don't know if that was the intention of the bill.
Yeah, and Claire, can I chime in here for a second? This is Delegate Pippy.
Yeah, go ahead.
So Delegate Lopez, from what I understand, was not trying to do anything on the criminal side at all. And so the reason she co-sponsored my legislation, her and I had extensive conversations this year. Obviously, we had extensive conversations last year, but she told us that there was an inadvertent error in her office, that there was anything included on the criminal component side. So I don't know if that's what her aide's referring to, but that's certainly not a criminal bill. So I don't know what it's transpiring at the moment, but I would agree with Claire that that is a civil bill, and I'm not really sure how that would be applicable to this conversation.
Got it. Okay. So let's So we're gonna, at the moment, we are gonna go with, we're doing a civil defamation per se remedy as contemplated in the Hester bill. We are looking at a criminal definition under the existing revenge porn that utilizes this new combined definition that was, or well, our council will attempt to craft a version of a combined definition that we believe is merging the contents of the discussion here today. I do want to ask one last question, and this is, I I just want to make sure we're not opening a huge door here. This whole issue about the web hosts, usually there's, the under the old rule of DMCA and all of this, that the web hosts would be shielded from liability if they have a takedown procedure and all this kind of stuff. And I swear I saw language to this effect in one of the old versions of this bill, but I don't see anything like that floating around this time. And I just want to ask about whether we're intending to put the business people into the mix here. And I guess not, maybe the intent deals with it. Delegate Bartlett.
Thanks, Mr. Chair. So I thought I saw, I can't find it now, but in the fiscal note under current law, and I'm gonna tell you which one it was. It gave us the section. Oh. So it says an interactive computer service as defined. Now, this is federal law, is not liable for content provided by another person, 47 USC section 230 F2. So that's there under federal law. Do we need to reference that, or is that sufficient that it already exists under federal law?
Yeah, I presume it's sufficient. Yes.
This is,
Senator
I was looking
Hester,
at,
and then we'll go to OPD.
okay, I'm sorry, can I just
Yep.
reference, it was under the Senate Bill 360 fiscal note in there on the last page.
I was just going to add that it's also referenced in the criminal part of the bill on page 4, line 20. Like it's already in the revenge porn statute, I believe.
Oh, okay. Oh, right. Okay. So if we're already, yeah. Okay. Okay. Great. Thank you. All right. OPD.
So, since we're talking about Section 230 of the federal law, I was just going to mention, I know there's been talk of modifying it to make interactive computer service providers more liable because of how much bad stuff is running around the internet. So, if 230 changes underneath this statute, it could end up creating liability. And I wasn't sure if that was the intent of this bill, if you want to create specific protections, or you just want to rely on whatever changes to the federal law made. That's all.
Interesting. Yes, Delegate Embry.
Given the incredible negligence of websites in protecting people from this kind of behavior, I would be strongly opposed to offering protection beyond what the federal government does. I mean, there's just unbelievable.
Oh, I see what you're saying.
You know
Yeah,
what I mean?
got it.
I would not want us to go further down that path of providing any additional protection.
Yeah, got it. Right. And I just wanted to make sure there was something. We weren't just, creating a wild spiral, but it looks like it's already covered. So, great. Okay. So, yes, Delegate Embry.
Oh, sorry. Nope.
All right. So why don't we do this first? Let's go ahead and move a set of conceptual amendments to the Hester bill. So we'll send this one back first.
So
And
move.
It's what we just discussed. So we'll retain the civil defamation per se for revenge porn, and then we'll utilize a Claire tweaked combined definition of deepfake and insert it into the revenge porn code, and we will call it a day. And so there was an amendment, or excuse me, a favorable on the amendment from Delegate Kaufman. Is there a second?
Second.
All right, all in favor of the favorable on the subcommittee amendment, raise your hand or say aye.
Can I just ask a question?
Yes.
Where are we putting the House side? Is we just doing this?
Oh, we're
inside
doing the Senate
bill?
first. We'll get to
Okay.
that.
So everything's happening inside the Senate bill.
Yep.
Okay.
Does anyone want to be recorded in opposition on that? Okay. Well, we are generally putting bills on one bills, putting everything on one bill this session. And so it would be my inclination to stick this on the Lopez bill. You're getting a head shaking here. All right. And if we're going to have this sort of an issue on it, then I would say we could also just move the civil bit out. But I would prefer we just put everything on one bill. We've been doing it all session. Why are
I
you
move to
shaking your head?
conform Jesse Pepe's bill to the bill that we just moved.
Second.
All right. No. Come on. We're not doing this. We're gonna put a pin in this. We've moved the Senate bill. We're gonna put a pin in the House bill. We have time to deal with this next week, and I'm gonna rope the chair in for further discussions. But we've been combining bills all session. Many of our colleagues have been eating it on this, and we moved the sponsors over. I hope we will do that again when we next meet in a few days. Are there any additional discussions on the remaining bills? Oh, sorry. And on the Werman bill, maybe we can do just a 1 minute on this. It's a bit of a new topic for us to get into business regulations on this. So I appreciate the conversation on that. We were quite a bit further down the rabbit hole on the actual criminal and civil bit. So I appreciate getting the committee thinking about that aspect of this. But I do think, given the timing in session, we will have to return to the topic of business regulations of the platforms on this. But I agree with Delegate Werman on this. Actually, from the beginning, I've thought the platforms were in a much better position to help us deal with this problem than these way after the fact random prosecutions here and there and lawsuits that we would do, because I know the problem's much bigger than that. So Delegate Werman, I want to thank you for your work on that topic. But again, we will be back to the conversation about the House bills at our next meeting. But with that, thank you, and we will see you next time.